Hello, my name is Reardon Stanford. I'm a board-certified family law specialist and I've been practicing law for over 20 years. You may know that Louisiana is a community property state. You may not know what that means. In Louisiana, we have what is called the legal regime of the Community of Atchison Gaines. This is a set of rules and regulations that governs property and obligations of the parties during the marriage. There are two aspects of community property: assets and debts. Generally speaking, assets acquired and debts incurred during the marriage are and are presumed to be community property. It's a rebuttable presumption, which means you can prove that it's not community. For example, property that you inherit during the marriage is your separate property. Property that is donated to you during the marriage, to you alone and not to both of you, that's also your separate property. Of course, property that was yours before the marriage, that remains your separate property. It doesn't become community property just because you get married. Those are just some of the examples. Further, you don't have to have community property. It is possible to opt out of it. You can execute what's called a separate property agreement, commonly referred to as a prenuptial agreement. It is even possible to execute a separate property agreement during marriage, but it's more complicated and it generally requires court approval. There are a multitude of rules that govern both community and separate property and how to divide it when the circumstances arise. If you are considering divorce or even marriage, it's in your interest to speak with an attorney. Please contact me at Hoyt & Stanford. We'll go over your circumstances and details and discuss your rights, obligations, and most importantly, your options. I look forward to hearing from you.